Hi, Jen Rubin, editor-in-chief of The Contrarian, back with one of our favorite contrarians, Andrew Weissmann. Andrew, welcome.
Nice to be here. I always say
It's,
that
I know,
nice to be here. I'm sorry to be talking about what we're about to talk about, but it's important.
exactly. But we have good news today, actually. Rumesa Ozturk, who was the Tufts student who was grabbed off the street, carted off by ICE, had a hearing today in front of a Vermont federal court judge, Judge Sessions. And what happened there? The judge did not seem very happy with the Department of Justice.
No, he didn't. And just to bring people up to speed about who this woman is, so people understand that the hearing that happened today in Vermont before Judge Sessions, the government did everything it could to avoid this day. So first, I'm going to read just very quickly how the Second Circuit, which is the appellate court in New York, how it described what happened to Ms. Ozturk. She's a graduate student who had, until recently, been living in Massachusetts lawfully on a student visa. On March 25th, 2025, 6 plainclothes law enforcement officers arrested her near her home without warning and drove her away in an unmarked car. Unaware of her location and unable to contact their client, Ostrich's counsel brought a habeas petition in the District of Massachusetts. That's how the legal case began. And for a full 24 hours, nobody knew where she was. Her counsel had no idea. And what had happened is the ICE agents had taken her, arresting her and swooping her up with no criminal charges off the streets of Massachusetts, taken her through New Hampshire, through Vermont, to Louisiana. And so that's where she was until sort of, essentially a New York minute ago. And the government said the habeas petition was improperly filed. It shouldn't have been filed in Massachusetts. You should have filed it in Louisiana. And the court said, no way. Essentially, you can't, here it's like you hid the ball. Here it's you hid the person and you kept on moving them. And the proper location was at the moment the habeas was filed, it was right for it to be in Vermont because that's where she was, and it's going to stay in Vermont. That's what Judge Sessions in Vermont said, and that was appealed to the Second Circuit, and that's what the Second Circuit said. And the habeas hearing is going to go forward as to whether she needs to be detained at this point. In other words, is she a risk of flight or is she a danger to the community? This is a spoiler alert. You see graduate student who is lawfully here on a student visa. So that's sort of the backdrop. I do want to, Jen, just take one moment to just highlight one argument that the government made to the Second Circuit. They said that the habeas law requires the person to name the actual individual who is detaining them. In other words, the prison warden, and you have to name them correctly. And here, obviously, Ms. Ozturk's counsel said, well, you hid her for 24 hours. How are we supposed to know that? And the government said, that's too bad. There needs to be that sort of unknown person argument doesn't work unless it's a substantial period of time, meaning for whatever substantial means, solely within the control of the government, you have no habeas rights. That was their argument to the Second Circuit, that unless you can name the person who's holding the person, even if we're not telling you and don't even let you know who your client is, that you cannot file a habeas. That, needless to say, was rejected by the Second Circuit. But I'm saying that because I just want people to understand that that is not a normal argument.
It's preposterous. It is absolutely preposterous. And as you said, the real reason for making all of these throw it against the wall, see what sticks kinds of arguments is they did not want to have the hearing that ensued today. Because guess what? The government's got nothing. And what ensued in that hearing, aside from the fact that she actually had an asthma attack, and one of the reasons she needs to be released is because of health reasons,
Right.
is that she presented her case and the government had literally nothing and didn't bother to cross examine her. What did the judge find and what did we learn about her during this hearing? Spoiler alert, those of you who saw my interview earlier in the week with her counsel from Vermont of the ACLU probably know a little bit about this, but what came out in court just underscored everything that her counsel had told us.
Um, so I think the big picture that came out was that it shows the utter cruelty of what the government is doing here.
Yes.
Even if you leave aside the sort of preposterous legal arguments, here's somebody, as I said, you have to examine. Let's assume that there's a good reason. This is a big if. Let's assume there's a good reason to deport this person after a hearing. After a hearing. Um, that's not a reason that they need to be in prison awaiting that if they are not a flight risk or a danger to the community. Lots of people who are charged with crimes are out on bail,
Yes.
but precisely because they're not a flight risk or a danger to the community. There's a presumption of innocence, and you don't put people in jail unless there's like a good reason that's proved by a certain level of proof. So that's one, which is that this was so needless. And and even if the government in good faith thought there was an argument to deport her, there was a way to proceed that was perfectly lawful where the courts would have a role and she would have a role. This is another example of the government just doing, this is one more case to add the litany to the litany of cases where they don't want the person to have a hearing, they don't want the judges to have a role. And then in terms of what really was shown in court, as Judge Sessions said, they literally, I mean, he used the words, literally had nothing other than her writing an opinion piece. And that could be the most that could be the most, you might hate that opinion piece, you might disagree with it violently. That's an opinion piece. I think anyone listening to this is going to understand and cherish that one of the things that it means to be American is people can say all sorts of things that you think are awful, and that doesn't mean you get deported. There has to be more than speech.
And what's more, as the judge elucidated, as her counsel pointed out, she is almost a model resident of the United States. She helps children. She's studying a topic about protecting children from the internet. She volunteers. Her counsel previous to this hearing provided dozens of declarations sworn under oath about what a model person she is. And the judge said, it's not just this case I'm concerned about. He said, if this case stands, millions of people could potentially have their speech chilled. What does that mean in legal terms, chilling speech?
So, to that point, one of the ironies is within minutes of Judge Sessions making this ruling, the Second Circuit ruled in connection with a Columbia student that the same thing had happened. And obviously, we're seeing that in so many other contexts in terms of immigrants who are being swooped up, as to quote Judge Wilkinson, stashed in a foreign prison, never to be heard of again. Chilling speech is when you do something, the government takes a position with respect to somebody that's so harsh and draconian that the rest of us think, oh, well, I don't want to say anything because, the government's going to look at this and could deport me. So, there's lots of news stories about the government looking at Twitter feeds, threads, there's a social media context to see what kind of things you've posted and what kind of opinions you have. You could be pro-Israeli, you could be pro-Gaza, I mean, all of that, but there seems to be a view that if you are anti an Israeli government position, which God knows, I'd say half of Israel is, that somehow makes you anti-Semitic, which would again mean mostly like half of Israel is anti-Semitic under that definition. And so
And
that
oh,
is a
by the way,
chilling.
being anti-Semitic is not a grounds for being deported either. Although listening to Marco Rubio, you wouldn't know that because it's so evident that they are punishing people who have taken a certain position that they've kind of given the game away. They've kind of let on because these people take a view we really don't like. We're going to start looking through everything they've written, everything they've said, and we're going to kick them out of the country.
Well,
That
Jen,
is
yeah.
mind-blowing.
So Jen, you and I think are particularly appropriate to mention this, which is I would not say that this administration is exactly friendly to Jews.
Yes,
And when you are having dinner with and socializing with people who think that Adolf Hitler should have finished the job and are not viewing Nazis as bad, but rather good people on both sides, it comes with really poor grace to see that claim of being against anti-Semitism used as a weapon.
yeah, exactly.
And it's as coming from a family that has like many Jews in America and across the world who have had a history of being discriminated against, but more than that, like having tons of relatives who are dead due to that. It's a serious issue that shouldn't be used cavalierly for political purposes.
Exactly. Exactly. And that, by the way, is the same tactic they're using to try to cut off money to universities by threatening them,
Right.
accusing them. And by the way, if you really cared about anti-Semitism, you probably would not have appointed, although it's now been withdrawn, a nominee to the U.S. attorney for the state, for the District of Columbia that held around with neo-Nazis and then
Right.
didn't tell the truth about that. But be that as it may, I think one is left, and we're going to switch focus just a little bit with the notion, and I think it's a correct perception, that this administration does not know what the Constitution of the United States says, or they don't care, or both. Kash Patel, who is director of the FBI, again, that's hard to sort of fathom, had a little back and forth with Senator Berkeley, in which he was arguing with the senator. What do you mean these people have due process rights? Do you think these people are got every one of these people are going to get a trial? The president of the United States, in an interview with Kirsten Wilker, was asked, "Do non-citizens have constitutional rights?" And he says, "I don't know." This is the guy who is charged with upholding the Constitution. These people don't seem to get it, or they live in a world in which they wished that people who are not citizens don't have due process rights. Have you ever seen anything like this from senior officials, from the head of the FBI? They not have a pocket version of the Constitution?
Well, the thing that makes it even worse, Jen, is the Supreme Court of the United States has ruled during this Trump administration. In other words, not this, you don't have to go back to, it's not like you're saying, in 1847, there's an arcane Supreme Court case. In the Judge Boasberg case, in that appeal up to the Supreme Court of the United States, that court ruled against this administration, the Trump 2.0 administration, 9-0, 9-0. Like, can I say that more clearly? That the people who were deported to El Salvador, I can't even say extracted to El Salvador, were entitled to a due process, and they were entitled to a pre-deprivation hearing. You can't get any more clear than that. And, subsequent to that, you don't want to hear Kash Patel saying, I don't understand that they'd be entitled to a hearing, or playing games about hearing versus trial. I mean, when you are in government, let alone the head of the FBI, you're saying, of course, they will be given the process to which they are entitled. Reasonable minds can differ and argue about what that process should be, what kind of evidence can be allowed, what kind of cross-examination should be allowed. All those are fair issues. That's not what's going on. Stephen Miller tweeted just a few days ago that due process does not apply to non-citizens. That is directly contrary to what the Supreme Court just ruled 9-0. To have somebody sitting in the White House thinking that's what they can say, to me, that is why you have the courts, the two courts right in the just a few minutes ago releasing two students at Tufts and Columbia, is saying these people are not a danger. They're not a risk of flight. They're not a danger to the community. They should not be arrested. You have the court saying all of these people are entitled to a hearing. You really have the sense that what is going on is that the administration says we're going to do whatever we want. And the burden then is on you, the individual affected, to stop us. And whether the courts say no, it seems pretty clear, even then they're violating the law. Remember, Mr. Abrego Garcia, there was an order for him, a court order for him not to be taken to El Salvador, and that was violated. So that was violation 1, and violation 2 was there was no hearing. He was just put on a plane and removed. And the third is we know that the government has said that was a mistake. And yet they're still not bringing him back when they're ordered to facilitate his return and release. So I really think that's what's going on. It's just you have to make a stop.
And I think if people didn't realize it before, the level of disdain this administration has for the courts, for judges, for orders, for the English language, for basic human dignity is way off the charts of anything we've seen, including this administration in Trump 1. And that's, I think, why you have two justices this week, Roberts and then Sotomayor, kind of speaking out in a way they don't usually, telling the administration, we get to decide what the Constitution says. We have to interpret what the law is. And I think now that's really being put to the test, and the lower courts are doing their job. We're going to see when these things travel back up to the Supreme Court whether Roberts really meant what he said.
Yeah.
Are you optimistic at this point that he's going to stick to his guns? Because if not, they might as well just close up shop, take off the robes, and go to the beach.
Yeah, I mean, look, I think there's certain issues that are going to be viewed as sort of losses for liberals, but I think on this issue of due process, respect for the rule of law, the sort of the presumption of regularity that usually is given to the government, I think all of that is something where the court is going to hold up and speak out. And I recently did a podcast with Mary McCord, and the title, which was "The Presumption of Irregularity," because
Yes.
they've thrown that to the wind. I think one other thing I just want to make sure people understand is, a lot of times people might just want to say, "Oh, well, Jen's like a lefty," or Andrew. I love this. Andrew's a lefty, which, by the way, when I was in government for 21 years as a prosecutor, that was like the first thing that people said. I want to make sure people understand this is not a partisan issue. The reason that you are seeing Judge Wilkinson, the Wall Street Journal, Joe Rogan, Jack Goldsmith, John Yoo, those are not people who are deep state liberals. They are people who on this issue see this as a rule of law and fundamental decency issue. And I think that is why cases like the Abrego Garcia case, who is still sitting in jail, have resonated with the American people, because it exemplifies so much what due process is and what people, I hope, feel in their heart, the way we're supposed to treat each other.
Well, I certainly hope that's the case. And if there's reason to be somewhat optimistic this week, it's because at least at the lower courts, the Trump administration is losing and losing and losing again. And now the question is whether the courts can hold them to that and make sure that the abuses stop. But thank you, Andrew. As always, I thank you for coming here and appreciate seeing you. But I'd really rather we stop meeting like this and go back to normal, because the presumption of irregularity is kind of hard on, the stomach and on the heart.
Yes, it is. But you're
Take
right.
care.
I think it's useful. I think it's useful for people to know there's two really good decisions today. There are two
Yes,
students who are
absolutely.
released, who should be released. And so we are seeing the courts stand up and do the right thing. And they're really good role models for all of us.
A great way to end the week. Thanks so much, Andrew. We'll see you next time.
Take care.